Welcome to Module 2. We are going to talk about understanding documents, terms, traps, and tricks. By the time you finish this module, something will shift for you. You will open a contract and instead of feeling confused or overwhelmed, you will start seeing it clearly. You will know which words to look for. You will know which section to slow down on, and you will know exactly when to say, hold on, this needs to change before I sign. That is the goal of this module. Not legal theory, but a practical vision. Let us start with the language that are commonly used. So, in lesson 1, we'll look at legal terms, what they actually mean in real life. Here is the honest truth about legal language. It is not difficult because the concepts are difficult. It is complicated because lawyers wrote it for other lawyers, not for you. But once you stripe away the grammar, the actual ideas are simple. Let me show you 8 terms that appear in almost every Nigerian contract. I'm going to explain each one the way I would explain to a friend over a plate of jollof rice. No lectures, no textbook, just plain sense. Number 1 is clause. A clause is a simple rule. When someone says, check clause 5, they just mean look at rule number 5. That is it. A contract is just a collection of rules that both parties are agreeing to follow. The danger is not understanding what a clause is. The danger is in assuming that because a clause looks normal, it's harmless. Some of the most destructive clauses in Nigerian contracts are written in the most casual language you can imagine. Take this tip. Read every clause, even the ones that look boring, especially the ones that look boring. You get why. Number 2, consideration. Consideration is the answer to the question, what are both of us getting out of this deal? So, you provide marketing services, they pay you 150,000 naira. Your consideration is the service. Their consideration is the money. Why does this matter? Because if there is no real consideration on both sides, the contract may not be even enforceable in court. A contract where only one party is given something and the other party is given nothing, that is not a contract. That is a favor, and favors cannot be enforced. So, a tip to take note of: before signing anything, ask yourself, what exactly am I giving and what exactly am I receiving? Write both of them down. Number 3, liability. Liability means when something goes wrong, who pays? This is one of the most manipulated words in Nigerian contracts. Companies love to bury liability clause deep in the document where you stop reading. Take for instance, you are a logistic company. A customer pays you to deliver goods. The goods get damaged. Your contract says the company shall bear no liability for goods damaged in transit. Meaning that this is their loss, not yours. You are protected. Now flip it. You are the customer and that clause is in the contract you sign. When your goods are damaged, you have no case because you already agreed to carry the liability. This is Nigerian reality. In Nigeria, most small vendors and suppliers are asked to sign contracts drafted by big companies. Those contracts always shift liability to the smaller party. This is why you must read liability clause carefully. Carefully. Number 4 is jurisdiction. Jurisdiction is the location where any legal dispute between you and the owner, the other party, will settle, any issue will be settled. This sounds like a minor details until there is a problem. Imagine you sign a supplier contract with a company whose head office is in Abuja. The jurisdiction clause says any dispute shall be settled in the Federal High Court, Abuja. You are based in Calabar. Every time you need to attend court, you are buying a flight ticket. Every time they want to delay proceedings, they just reschedule. This is dangerous. That clause alone can make it too expensive for you to pursue what is rightfully yours. A red flag to take note. If the jurisdiction clause puts the court far from where you operate, negotiate it or add, dispute may be settled in the high court nearest to either party's principal place of business. Number 5, force majeure. Force majeure is French, like for superior force. Is a French word. In plain English, it means extraordinary events that are completely outside anyone's control, like pandemic, government shutdown, natural disaster, wars. This clause usually say if either party is unable to fulfill their obligation due to a force majeure event, they shall not be held liable. Sounds fair, but watch how it is applied. During the COVID lockdown of 2020, many Nigerian companies used force majeure to justify not paying suppliers, not delivering services, and cancelling contracts, even for situations that had nothing to do with COVID. Why? Because their force majeure clause was written so broadly that it covers almost anything they wanted to escape from. A tip to take note of: a good force majeure clause should list specific events and should apply equally to both parties. If the clause only benefits one side, that is a big problem. Do not agree. Number 6, NDA, non-disclosure agreement. An NDA means what we discuss stays between us. Take for instance, you are pitching your business idea to a potential investor. Before you share the details, you both sign an NDA. It says you cannot use or share this information outside of this discussion without my permission. That is the clean version. But there are dirty versions of NDA circulating in Nigerian business circles that are written specifically to take ownership of your idea, not just keep them a secret. We will go deep on this in the next lesson. For now, understand that an NDA should protect both parties equally and should never claim ownership of knowledge or skills you already had before the meeting. Another red flag to take note of: if an NDA says all ideas and concepts shared shall become the property of the company, do not sign it. That is an idea theft clause disguised as confidentiality. Number 7, indemnity. Indemnity means if my actions cause damage, I will pay for it. You hire a contractor to renovate your office. The contractor, the contract has an indemnity clause saying The contractor shall indemnify the client against any damage to property or injury to person arising from the contractor's work. That means if their workers break something or injure someone, they cover the cost, not you. That is a fair indemnity clause. The one to watch out for is when you are on the receiving end of an indemnity clause that is written so broadly that you become responsible for things that were not your fault. Another red flag: always read exactly what you are indemnifying against. Broad indemnity clause can make you financially responsible for events completely outside your control. Number 8, exit clause. The exit clause is your legal door out of any agreement. And I cannot stress this enough. Every single document you sign must, I said must have one. Hey, listen very carefully. I do not care how good the deal looks. I do not care how much you trust the other person. Without a clear exit clause, you can be legally trapped in a relationship that is destroying your business with no way out. The standard version is simple. Either party may terminate this agreement by providing 30 days written notice to the other party. That is it. 30 words. But without those 30 words, you can spend months or years stuck in a deal that is bleeding you dry. Some contracts have exit clause that are technically, they put it technically there, but are written with so many conditions and penalty that living is almost impossible. That is not a real exit clause. That is a trap wearing a disguise. So, action point: before signing any contract, find the exit clause, read it, understand it. If it is not there, add it before you sign. If it is written to make living impossible, expensive, or difficult, negotiate it. Negotiate it. Because now let's do a lesson. Let's have a lesson recap on the terms which we discussed. On the 8 terms we discussed about, let me say them fast so that they can stick. Number 1, we talk about clause. A clause is a rule in agreement. Simple. 2, consideration. What each party gives and receives. 3, liability. Who pays when things go wrong? 4, jurisdiction. Where disputes get settled. 5, force majeure. Protection from extraordinary events. 6, NDA. A confidentiality promise. 7, indemnity. Financial responsibility for damage caused. Then 8, exit clause. Your legal way out. So next lesson we go into the 9 type of documents that cause the most damage to Nigerian entrepreneurs. And I promise you, at least 2 of them are documents you have already signed. Let's go there.